Yes.
The control number address I have to mention item number 19.
19.
Today we have some difficult electricity come after
Next week, my lord. We commencing from 4th.
19. When?
last part of November.
Last quarter.
My lord, there is a stay of the proceeding. So I guess
2024 May. It is said
second week of November, my lord.
on the prayer of third week in the
Third week, yes.
in between. In between.
My lord.
Yes.
On the prayer of Mr.
Is the husband.
A.J. Hazikal and counsel for the petitioner. They are not being objected to that. And Mr. Edher for respondent 1 and 2. List this matter in the third week of November.
Obliged.
Also, interim may be continued.
Interim
Interim
order
stay or
first,
interim?
yes.
Highly.
Yeah, please, Lordship.
Yes.
I beg to mention item number 13.
13.
Yes, Lordship.
Yes.
Actually, the engaged counsel, he's sick. So inform.
Hmm?
Actually, the engaged counsel, he is sick. So inform me over phone, Lordship,
For
adjournment.
appellant.
I'm appearing on behalf of respondent number 1 and 2. For advocate M. Devnath, Lordship.
On the prayer, MS so and so learned counsel appearing
Yes,
on behalf
ma'am.
of Mr. M. Devnath learned counsel for receiving 1 and 2. List this matter after 4 weeks.
Yes. Obliged, Lordship.
PJ Lordship, with the consent of the adversary, I beg to mention items 4 and 5 for adjournment.
4 and 5.
Yes, Your Lordship. 4 and 5. Your Lordship, may I pray that the matter be fixed on the 5th of November.
5th of November not possible.
Any other date, Your Lordship, in the first week?
On the first week is not possible. On the prayer of Mr.
C. Gogoi, Your Lordship.
C. Gogoi. 4
Respondent.
for respondent.
He's for the respondent. I'm for the petitioner, Lordship.
For respondent. And the prayer not being objected to by learned counsel for the petitioner.
Yes,
List
Lord.
this matter after 3 weeks.
Lordship, after a week, Lordship.
After 3 weeks.
A date may be fixed, Lordship.
Lordship.
After 3 weeks. After make it after 2 weeks. Just give the
2 weeks, Lordship.
Obliged.
Yeah, please, Your Lordship. Your Lordship, item number 8.
8.
Yes, Lordship.
Yes.
Lordship, kindly adjourn this case for today.
Why?
Your Lordship, the senior engaged counsel is indisposed. The senior engaged counsel is indisposed. And we have communicated with the appellant.
You are for petitioner, appellant,
No.
Clement.
Respondent. Respondent.
Clemens.
Yes.
On the prayer of MS
Deepshika B. Kalita.
learned counsel appearing on behalf of Mr.
Argoswamy.
R. Goswami learned counsel for respondent number 1, 2, and 3. List this matter after 4 weeks.
Bless Lordship.
Yes.
Lordship, I have taken instructions from the client. Lordship, here what has happened is that the proposal was sent in 2019. Now the present Treasury Officer, she has informed me, Lordship, maybe at that time the petitioner had not come to claim, Lordship, because they have to come and claim the thing, because of which maybe the payment has not been made. Now I have informed the Treasury Officer. The Treasury Officer is just requesting the petitioner to come to the office once. Lordship, that can be today, tomorrow, whenever. And Lordship, it has to be, if the proposal was sent in 2019, now it has to be revalidated by the AG. But the formalities which the Treasury Officer has to do, Lordship, they can do it instantly, Lordship, subject to the petitioner coming for the term. Just verifying once, because, and in the meantime, Lordship, the Treasury Officer has requested if the petitioner can come with the account statements for the year of 2019 just to verify whether or not the payment has been made. It will be easier. So if the petitioner can come and meet the Treasury Officer once, Lordship, it will be much easier, Lordship, if they...
No doubt they will come. Earlier also they were, Lordship, but he was citing one or the other reason, Lordship, not making the payment.
solve the matter
Lordship,
for the once and for all.
Lordship,
In that case, we'll record his submission.
Lordship,
We'll
Lordship,
direct you to go
Lordship,
visit the thing and
Lordship.
the treasury officer.
yes, Lordship, a new
Along
Guwahati
with
treasury.
all these
Lordship,
the relevant documents, including
The-
the accounts.
Yes, Lordship, statement
Of
of
which
2019 for
2019 accounts.
Lordship. Once the petition,
What kind of Lordship?
bank account statements, Lordship, just to show.
Lordship. Lord, that can be recorded.
Yes, Lordship, if 2000 and once the petitioner goes, Lordship, the required other additional documents they can.
It takes time, no?
Lordship can fix the matter after 3 weeks, Lordship. After going, Lordship.
We'll close it today. You
Lordship.
go there anytime. When do you want to go? You give the date.
Lordship,
You visit the treasury officer. Why unnecessary?
Lordship,
There is
Lordship.
some 2018 matter.
Lordship, but the matter cannot be closed. That was an interim direction, Lordship. That was an interim direction. There were other prayers also, Lordship.
What are the other prayers?
Lordship, for payment of Lordship regular pension, etc. Lordship.
Okay. Yes, you have deducted certain years of service.
Lordship, that has been done by the parent department, Lordship.
Yes.
In fact, Lordship, may kindly peruse page 31 of the petition.
31.
Lordship. The pension case of the petitioner has been returned by the Accountant General, Lordship.
Yes.
Page 31, Lordship. It is written to the Irrigation Department. In inviting reference to the subject matter, I am to state that Sri Govinda Pathar, retired helper under the Executive Engineer of Guwahati Road Division, was engaged as master road worker on 1/3/93 and retired on superannuation on 1/31/2009 as a temporary master road worker. His service was regular with effect
No,
from
the deduction of 6 years has been interfered by this court.
Lordship, even it is Lordship, he is only 16 years, Lordship. If it is not deducted, Lordship, his total service will be 16 years, Lordship.
Lordship, there were other, I have placed some judgment of the case 36.
That's what I'm saying. You cannot deduct. But they
Lordship,
found-
They cannot deduct, Lordship. If he is not deducted,
according
even
to
then he
even
is not
if it's
qualified.
deducted. Assuming that they have not deducted.
Lordship.
Even then you don't have the qualifying years, 16 years.
He is only 16 years, Lordship.
So what relief can be granted?
Lordship, may see page 36, Lordship, there is an order, Lordship, similar situation, Lordship.
No, that we have seen it.
He expired, Lordship, different case, right? Okay, page 31 अपने घिराई दिखे.
When you were appointed? 1993.
Lordship.
No, as per this Rajbansi's case, you cannot deduct that. In that case, when he died,
No, he not died. Lordship.
When he retired?
He retired on 31/5/2009.
Yes.
Lordship, the texts are different, Lordship. They are
Exactly same, Lordship.
No, in that case, immediately after the
in any case, Lordship, the pension proposal has been returned by the Accountant General. Lordship, my friend is there.
Accountant General is a party, eh?
Lordship, he's a party.
Why are you not filing the affidavit?
I was there to submit same thing because I have received.
No, the finance is only in respect of terminal benefit.
My lord,
That,
yes,
that
yes,
cannot
yes.
be. That will pass.
I'm appearing on behalf of Accountant General, any Assam. I have received various comments. I have already sent for vetting, my lord. Within,
What does it say?
that is the same. It is
No, you
same.
cannot have the same. Have you read the
Because
judgment?
saying is, see, our saying is this.
Other earlier judgment.
And here,
Which has attained
here
finality.
question is,
Rajbhang
Sandhita
says
cases, 6 years may not be deducted. That's all right. We are not on that. Where as per OM, because as per section Rule 31, these three conditions are there. But apart from that, there is an OM. That 20 years service, if it is got, they are entitled.
No, that's
But
what-
after, no, let me submit the law. Because after deduction of 6 years, if 6 years goes away, it is then also his service is, according to my record, it is 16 years. But he is, as a master worker, he will be entitled for pension apart from Rule 31, but he has to complete 20 years. Now his services, if we do not deduct it, then also it becomes 16 years only, not become 20 years. That is our stand regarding pension. Terminal Gazetteer, my learned friend has already might have submitted.
No, terminal pension.
That is that. Here my stand is this. Lordship may produce only because he will come up on by affidavit. Only I may, if your Lordship give an opportunity me for 3 or 4 days after vacation, I'll file it. Because today, tomorrow holidays or Tuesday, or next Wednesday, you may Lordship.
What
make it.
about this judgment?
The judgment, I am not on. Judgment, your Lordship, which judgment, my Lord? Sanjita.
Rajbhang says.
Page 36.
I will look into this also because as I am Lordship, I am praying for, because otherwise it will be precedent for that. That is why I want to file on this and file on by affidavit. This is going to bring only 7 days time I am paying, my Lord. Next Wednesday.
No, this has been long back.
No, that's all right, my Lord. I am praying for 7. We are waiting for 6 years, no doubt, due to maybe my fault. But I am praying for decision before now for ends of justice for 7 days.
Judgment was passed in the year 2016 and it has attained finality. This
That is the Lordship. If he can wait for 6 years, he can wait for 7 days. If my affidavit goes against me, your Lordship is very much, he'll be entitled. But I am, because I have received Paravai's comment, I am praying for 7 days. I am praying for only 7 days, my Lord.
Master roll worker,
Yes, my Lord,
Yes,
everything is correct. I am fully agreeing with your Lordships.
retired long time back.
Yes, that is also I am agreeing, my Lord. Only I am praying once 7 years we are waiting, we can wait 7 days for ends of justice so that I can bring on record, because this affidavit got delayed due to my fault. And due to my fault, it cannot
We
be.
will dispose it this reporting that.
No, because here this,
I'll report this.
no, regarding that, I have to bring on record.
Because denial is, sir,
No, because
denial is because of the deduction of 6 years.
the Lordship may put on record. But this is an instruction. This is an instruction from me, because I want to bring by way of affidavit.
You're not going to change anything.
No, because that point I'm not here. That point is whether it is not taken up, because regarding that judgment,
Not only
it's
one.
closed. That is I'll take, because if Lordship, my humble submission is that today,
Sir,
if
there are
judgment covers,
2-3 judgments.
I cannot. If judgments are favorable, I cannot, my Lord. My saying affidavit, it will not change or alter the entire judgment, my Lord.
Exactly.
But, my Lord.
Therefore, I'll
But-
record your submission.
Yes, no, but
and
I
I'll
may
dispose of the
be,
matter.
for ends of justice, I may be allowed to file affidavit in opposition. 7 days time, I'm not praying even 2 weeks, 3 weeks, only 7 days because of holidays. Because 4 days are holidays, Thursday, Friday, up to Monday. Because I cannot bring on Monday. Monday I'll be getting back. Wednesday I'll get it. Let's see, Wednesday, because I am praying. No doubt, your lordship may point out that this affidavit got delayed due to my fault. Maybe my fault, because due to my fault, my client also should not suffer. Anyhow, my lord, I am praying for 7 days.
I understood. What do you say about this order in other cases?
If after deduction also, Lordship, they will be governed by the new pension scheme if they are entitled, because the services were regular. Lordship, if they are entitled, Lordship here. Lordship may have the matter on after 1 week, Lordship, then that day we'll, on the basis if we have to oppose, we'll oppose, otherwise we'll concede, Lordship. We'll consider
After 1 week.
after 1 week. In the meantime, we will take care of
For
the.
dismissal.
Yes.
Heard Mr.
I'm Bhagavat.
Learned counsel for the petitioner. On the prayer of Mr. Mr. CKS Barua. CKS C. Barua, sorry. C. Barua. Learned counsel for the respondent number 7, Accountant General. And Mr.
A Charlie, Lordship, for respondent.
as well as Mr. Enupadhyay, standing counsel for
1, 4 and 5.
1, 4 and 5. 1, 4 and 5.
6 also.
Then 6. Then
3, Lordship.
3. Still understanding for and Mr. You just press for a week's time to file affidavit. Mr. Since the matter is pending since 2018. No, before that. Praise the Lord. Next paragraph. Since the matter is pending since 2018, it relates to claim of pensionary benefits. Come on. Let this matter be listed after a week for final disposal.
Also, in the meantime, whether he will appear before
The petitioner.
The respondents who filed their response on or before. No, within these 2 weeks. On or before the next listing. On or before the next listing. We'll take it up and
Lordship.
next paragraph. Mr. On the instruction, Mr. H. Elliott, Standing Counsel Finance Department, submits that the petitioner is required to visit the office of the Treasury Officer of
New Guwahati, Lordship.
New Guwahati. New Guwahati.
New
Treasury
Guwahati.
Officer,
Yes.
New Guwahati. So as to work out the
For the formality
payment for
for terminal gratuity.
terminal benefit. Terminal benefit.
Lordship.
Having considered the submission level, London Standing Counsel for Finance Department, Mr. H. Elliott. In the meantime, it is directed that not in the meantime. It is directed that the petitioner shall visit the Treasury officer at New Guwahati with all the relevant papers which may be required for payment of terminal benefits, required for process for payment of terminal benefits. Within
7 days.
Sure, date may be a specific
Within-
date.
within
It can be
2
given. They will be more prepared, Lordship. Any date.
by when?
Date.
By 5th?
Lordship.
By on 6th, 06/11/2024.
6.
It is needless to observe that the Treasury Officer on such visit shall process the complete for payment of terminal benefits to the petitioner in accordance with law, in accordance with applicable rules.
Also, can I
Miss
get
the
a
matter on when? After 1 week, when? 7th. Let us, 7th.
Seventh of
You just, if you cannot, I mean, he'll be filing affidavit because he is the one who has returned it.
Lordship.
If you cannot, you get the written instruction and mainly go through the judgment.
Lordship,
We'll,
Lordship.
Maybe on law point.
Law point, Lordship. That,
we'll decide, we'll
Yes.
hear you and decide.
This is a transfer matter, Lordship. The petitioner is a CISF personnel. He is working as a constable CISF, and he is aggrieved by the fact that he has been transferred in violation of their own guidelines. That is the basic issue here. And in fact, this is the third round of litigation.
Are you seriously pursuing?
Lordship,
Are you seriously pursuing? It's a transfer only. Where are you now?
I'm here itself in my home center.
enjoying the stay order? only?
No, not enjoying, because obviously Honorable Court does not pass stay orders that without any reasonable basis. Fact is that it's evident from here that he, in violation of the guidelines, their own guidelines, he has been transferred. Now, in case of CISF personnel, there is a transfer guidelines, posting, etc., wherein basically the issue is their posting details are like that. In the first tenure, in the first part of the tenure, one has to be in an out-of-home sector, and for 7 years. And beyond 7 years, for 14 years of his initial service, he was in out-of-home sector, including hard 10 years and etc. And when this transfer order came, when the first writ petition was filed, there is one more condition. On completion of 25 years of their service, a person is entitled to be posted in his home sector. His home sector is the state of Assam, and there is only one unit here at Bongaigaon, BGTTP Bongaigaon, and where he has been posted only from the year 2016, and he was transferred out in the year 2020.
Is it a rule? Is it an act? Guideline is an act.
Lordship, of course,
Is
it
it
has to be, as it is, there is a guideline there. It has to be, that has to be given due consideration. That is what we are. And also the other personnel, like him, after 25 years, they have been shifted to the home sector, they're still here. But he was, at the point of time when the transfer was made, at the time of the first writ petition, he even submitted an affidavit stating that he is unwilling to accept the promotion as well as transfer because of the completion
I'm
of
asking whether the guideline is a form of statutory rules.
rules that obviously, Lordship, that I cannot.
Supreme Court is very clear.
Yes, there are
It's a guideline,
decisions.
not enforceable.
But even if Lordship, the departmental Lordship, the manual is taken into consideration, which they have referred to in their affidavit, even as per that, supposing a person can submit his unwillingness to take a promotion or transfer, that is admissible. And after that, if the reasons given are found to be acceptable, then that can be accepted. He can be as per his wish, he can be allowed to remain in his original post. That is admissible. But after 1 year, subject to the arising of vacancies, etc., he should be again offered another promotion after 1 year. That is what their manual says.
No, why you have been transferred on promotion?
Transferred on promotion.
You want to
I submitted unwillingness certificate.
You want to forgo that.
I forgot everything.
still
Promotion,
there-
seniority, everything.
Still then they want you
Still,
to
they want me to, yes.
with on transfer.
No, I want that I'm willing to forego
No, on
seniority, everything.
promotion, on promotion. They are transferring you
Yes.
on promotion.
Yes,
even if you don't, even you want to forgo that promotion.
yes. Everything, transfer, promotion, seniority, everything, subject to the condition that I am allowed to remain in the home sector because I've completed, as of now, I've completed more than 28 years.
It's okay, it's a guideline.
That has to be given some, because even they go into that.
NK Singh's, in the case of NK Singh, Supreme Court says, Honorable Supreme Court says you have to, if it's a profess norms, you have to comply. But in other judgment also, since it's a guideline,
Yes, strictly in accordance
it
with
is
that.
not enforceable. And
Strictly, not to be, yes, it's admitted in terms of
so your
strictly in
report-
accordance with that. We
that
cannot
has been
insist.
rejected.
We cannot insist.
Your-
Strict, yes, Lordship.
Your application to forgo the promotion
Yes,
has been
that
rejected.
has not been accepted by them. But even then, on what
No,
grounds?
people are filing a writ petition for promotion. Why you want to forgo? Or else
I'm
you-
willing to do so for forgo my promotion, seniority, everything. If I'm allowed to continue in my home sector, and I'm also entitled, Lordship, in terms of the guideline. If
In terms
others,
of the guideline, that's what I'm saying.
Lordship, if others,
Guidelines are not enforceable.
Lordship, yes, even if that is taken into consideration, that in terms of the guideline, I cannot insist. But why others, in terms of the guidelines, are given promotion and posting in terms of that guidelines? When others have been given, even I can submit a prayer for consideration on in those terms, at least. And they say that on administrative, of course, the guidelines say in terms of administrative
Where is the
excellence.
guidelines?
Guidelines at page Lordship 24 of my writ petition. I'm sorry, 39. The circular dated 25/9/2007, page 39. And the relevant clause, page 39, has the Lordship got it?
Yes.
Yes. And the relevant clause is at page 41. Tenure of posting, clause 12, page 41. Clause 12. Out of home sector and home sector, tenure for posting in respect of NGOs are subject to availability of vacancies, operational and administrative needs and new inductions. The details are as follows. First tenure, 7 years in units in out of home sector, excluding basic training. Second tenure, 12 years in units in home sector. Third tenure, 6 years in out of home sector. Fourth tenure, remaining service home sector. That is what these guidelines say. And during the note says, during the intersector transfer for third tenure, the individual shall be asked their choice of out-of-home sector from among the existing OHS by giving their preference to the OHS in the order of priority, and effort shall be made to accommodate their out-of-home sector such choices on merit subject to availability of vacancies. Explanation says merit shall be based on the duration of OHS in months already served. In case of tie, preference would be given to those having a higher age. Lordship, and my details of posting, they have given in their affidavit, they have submitted in the affidavit also. We have submitted in our petition also, but I think it will be more substantive if I go to take your Lordship to their affidavit, because that can be given more authentic. Page. So Lordship takes up the affidavit in opposition filed by them, page 48. They have
Serial number 113.
page 47 starts the personal details. And page 48 is the posting detail of their affidavit in opposition.
47 is 112 madam. Now serial.
Oh, serial number,
112.
112. 112.
Yes.
48.
48 112.
113, Lordship. 113 is the posting details of the petitioner. He started his service from 22/5/1996. RTC Barwa. This is an out-of-home sector. 1/2/1997 Nalco Daman Jodi. This is also an out-of-home sector. 2000 SSTPS Shaktinagar. This is also an out-of-home sector. 2003 Unchahar 15/2003. This is also an out-of-home sector. 2007, 11/4/2007. Then next, Phel Haridwar. This is also out of home sector. That is from 22/5/1996 to 11/4/2007. He was posted in out of home sector. He was there in out of home sector postings. Oh, sorry. On only on 1/7/2007, he was transferred to BGTPP Bongaigaon. This is a home sector unit. Only in the year 2010, from 1996 onwards till 2010, he was there in out of home sector units for 14 years, as I've already submitted, out of home sector. From 2010 to 2011, 2016, out of he is in home sector. 2010 to 2016. That is, oh, ठीक है, 16. In between 2011, he was again transferred to Durgapur. This is a out of home sector. So at the time when he was transferred on promotion in the year 2020, around 8 years of service he had rendered, 7 years of service he had rendered in a home sector unit. So what we were asking that, and most important, he was nearing 25 years of service. He had just 3 months to go into complete 25 years when he has again been transferred to an out of home sector unit. So all he was asking for is that, as it is, I have completed my tenure in out of home sector units. So I am willing to forego, even if you are willing to accommodate me in the home sector unit, I am willing to forego my promotion, seniority, everything. That is the only reasonable prayer which we made before him. And the reason which they had cited for rejecting my prayer, they can reject my prayer in terms of their departmental manual. It is there. But after 1 year again, they have to offer me another promotion. The ground cited by them for rejection of my prayer is that as he had put conditions. Now, if they that I have made a conditional prayer, that only subject to the condition that I'm willing to remain in the home sector, I'm willing to forego promotion. That is the only reason. Now, no doubt Lordship had correctly inferred that this is not a rule, this is not a statute, the guidelines. Yes, I cannot place from their record that this is a statute or a rule. It's a guideline, it's a circular. What has been stated, it's a circular that has been referred to as a circular there. But this has to be read along with their manual also, which are in the nature of a statute, not in the nature of a statute. It is a statute which they have been relying also. That in terms of the manual, they can employee can forego promotion, etc. But that is what they say. But conditions, as regards condition, obviously it's not there. If I may just
Are
refer
you agreed by the transfer, or are you agreed by the rejection of your application to forgo the promotion?
Two are interlinked here, because I am willing to forego my transfer
Basically,
promotion.
you are
Yes.
agreed by the transfer.
Transfer, basically, yes, transfer.
So you want to be here,
Yes,
provided even if you want to be here and to forgo the transfer, the promotion. You want to forgo the promotion
yes, forego promotion.
because you want to be here.
Seniority, yes, I want to be here.
You cannot dictate like that.
That is not should be.
They are right. They cannot be. You may have a different. If you have a different ground for reconsideration of your transfer, if they may consider it, but then you cannot put a condition. Otherwise, everyone will have to.
What they say is that I can be here, but in the home sector, there is a guy in terms of the guideline. Again, they cite the guideline here. Why I cannot be posted here? Around only 60% of home sector personnel can be here in the home sector. That is, Lordship will kindly take the impugn order at page 62 of my petition. Even they are referring to guidelines here. page 63, paragraph 4, where they are referring to the guidelines. Various note to below para 4 of posting circular guidelines state that home sector posting will be considered subject to availability of vacancies in home sector. Would be calculated with stipulation that the sector should not have more than 60% personnel, 60% of home sector personnel. These shall be applicable both for home sector tenures, second and fourth tenures. Now, what they are referring to again for not conceding to my prayer for remaining posted in the home sector, they are referring to that particular clause in that guideline that 60% of home sector personnel only can be posted in the home sector units. But we have stated in our, we have shown also details that at around this point, there were less than 60% of home sector personnel in the home sector unit. Yeah. Now, when they are referring to that particular clause, that only 60% of home sector personnel can be allowed to be posted in the home sector units, they also ought to have referred to the fact that there are more than 60% personnel, so we cannot accommodate you in the home sector. That much of fairness we can accept. We can expect from the employer.
That's all.
One can they cannot be arbitrary in their decisions.
Any judgment?
Uh,
Any judgment in your support?
regarding arbitrariness, not so there are so many judgments that for the decision
No, would like to place some any judgment in your support.
right now on arbitrariness. Also, that is a settled proposition that the employer cannot be arbitrary, even if administrative exercises guide them.
There's no arbitrariness. Rather, they are following the guideline. What they are saying is at para 39, a personnel can be posted anywhere on promotion.
Yes, anywhere. Then why that? Yes, they are referring to that.
And you said you are to complete you for completion early. There is 3 years to go, 25 years to complete 25 years.
I have completed. I
By
have
now you
completed
might-
more than 28.
No, you might have
More than
completed
28. More than 28. More than 28
In
years.
your representation, you said 25, 3 years to go.
No, at that point of time, at that point of time,
You will
I was
consider
nearing.
at that point of time, not now.
I was nearing completion.
That time, then it was passed that time only, not this today. Order
Lordship,
has not been passed today.
Lordship will kindly consider this at while taking into account taking into account my
Even
prayer.
if guidelines gives you, basis to claim, it's not enforceable. Rather, in
Lordship,
fact, they are following the guidelines.
no, they are following with the Lordship for allowing me to for consideration of my prayer for accommodating me in the home sector. They are relying on the guidelines that 60% a home sector person can only be accommodated in the home sector units. They refer to the guidelines. At the same time, they do not say that how much of what percentage of the personnel in the home sector consists of home sector
Is there
personnel.
any provision under the guideline that if a person is transferred on promotion, he can forgo and claim to be.
He can
taken
forgo.
in the same-
He can, Lordship will kindly take up their affidavit.
You can forgo.
They
so you
went
can
close.
forgo, but then is it a condition? Is there any provision that if a person is transferred on promotion, you can forgo the promotion, you can be continue to be in the same place of posting or home posting, home sector? Is there any guideline?
Regarding condition.
Under the guideline, is there any provision which stipulates that if a personnel is promoted, transfer on promotion, he can forgo the promotion and can be continue to be posted in the home sector. Is there any guideline, any provision?
Lordship,
That
clause
is your
12,
that is your claim only.
yes,
Number
my,
one, you have completed 25 years now, so that you are entitled to be posted in the home sector.
yes.
Number
That
two, 60% what they are relying
Yes,
is not correct. is not it?
60% is not correct. We stated
So
that,
that is third
Yes.
one is, since you are willing to forgo the promotion, you should be considered to be retained, considering that you have completed 25 years of service, which
Yes.
entitle you to be retained or posted in the home sector. That is your
yes, that,
submission.
that consideration has not come there in the impugn order regarding 25 years. That consideration has not come.
That time,
Then-
how can he consider you have not completed?
No, at that point of time,
At that point of time, it's all on record
21,
that you are yet to complete 25 years,
Lordship-
3 years to go.
21.
24
An
years.
order passed that time, not today. You might have completed today.
Lordship, in 21, complete Quran.
That's in the impugn order.
Lordship, in the impugn order, at least that consideration ought to have come, which has not come.
It says,
Because
it
it
says
has,
you are yet to complete 25 years, only hardly 3 years to go. That is recorded in the impugn order. Yes,
My
why,
lord,
why you are after him?
my lord, yes. My lord, in the first my lord, submission they have stated that he is a fireman appointed in my lord, CSF, and only one place is at Bongaigaon in home section, but nowhere in Assam, that post. My lord, regarding fire service. And petitioner in is Bongaigaon since 10/6/2016. First round of litigation, matlab, earlier there was a subsequently litigation, matlab, they have challenged matlab, the order of 2020.
What is the normal tenure?
No, yes,
What is the normal tenure?
normal tenure, matlab, yes, as per the guideline, matlab, after matlab, 25 years of service, he may be in home station. But that too, matlab, subject to the matlab, availability and matlab, yes, he is not the single person from Assam posted in CSF and fire unit. There may be some other person also. So if he occupy
We
that
don't know.
post,
You must be knowing.
matlab,
You must be knowing. We don't know.
matlab, I am
How
pardon.
many persons are there? How many vacancies are there? Whether he can be adjusted or not? That you have not said so.
No, fact is that matlab, he has to establish that he has any right. What right he has, matlab?
Forget
Huh?
about that.
Matlab,
Substantive justice.
matlab, he is continuing in the same post since 2016. If
Now,
and
now
again,
he has
again
completed 25 years.
yes,
Consider-
now
consider his case.
now completed. Matlab, now completed because of the matlab,
Forget about all these things. Now you are directing you to consider. I will direct him to file
matlab, this is the third round of litigation. Earlier twice matlab, honorable court directed and
That time it was
submitted
different.
representation. Matlab.
Now we'll direct you to consider his case. We'll file a representation on the ground that he has completed 25 years. As per the guidelines, he is entitled to be posted in the home sector. Right?
Matlab.
This is what you are admitting.
Yes,
That after
sir.
25 years, he is entitled to be posted in the home sector.
That is there. Matlab. Yes.
Right.
As per the guideline, that is there. But at the time of this matlab, representation, matlab, he has not yet completed. Matlab, 4 months to go to complete the 25 years. And this also be matlab, noted that matlab, since 2016, he is in the same place.
That's why I'm saying, what should be the tenure? Normal tenure.
Uh,
What is the normal tenure?
normal tenure is matlab, 3-4 years. Matlab, he has to be transferred.
That is 3 or 4 years.
Matlab, 3 years. Normally 3
Where
years.
it is? Where it is given?
Matlab,
there in the guidelines, clause 12. Tenure is
tenure of posting is.
guidelines, clause 12.
Tenure of posting.
First tenure, 7 years in units in out of home sector. Second tenure, 12 years in units home sector. Third tenure, 6 in out of units.
And
remaining service also. This is which
when
tenure are you
when
in?
he is
Which tenure are you in?
now he is in
Tenure,
Which tenure are you in?
right now,
in
fourth.
now
Last-
in fourth, but when the order is passed, matlab, he is in the third tenure.
No,
but
no, I was in
still,
the fourth tenure.
no. The
Yes, fourth tenure. Because I had completed 7 plus 12, 19 years. 19 plus 6, 19 years.
Now he is in fourth tenure.
12 plus 19 plus 6, third tenure. এটা কিমান বছৰ হ'ব?
It will be 28 years.
25. If he completed 25 years, then only he will come to the fourth tenure.
Now he is.
At the time of filing the representation, he has not completed 25 years.
Impugn order was passed.
Impin order was passed in
Lordship,
20,
Original transfer cum promotion was passed in the year 2020. It was 18/12/2020.
first order 18/12/2020, subsequently representation disposition 16/3/21. Then
No. Yes, pursuant to the Honorable High Court's order, the impugn order in this writ petition has been passed on 16/3/2021. And Lordship, on 16/3/2021, I had completed 25 years of service. So that consideration should have come in the impugn order.
1996,
21 were completed.
join on 22.
At the time when the original promotion cum transfer was passed, rolled out.
Yes, heard MS D. Burger and counsel for the people. And also heard Mr.
KK Parasar,
A.K. Parasar,
CGC.
CGC, for all the respondents.
all are.
All the respondents. We're directing you to file an affidavit, representation
Representation.
in view of the change, in view of the lapse of these years, since you have completed 25 years.
Yes.
And Mr. You consider his representation and first appropriate order. That's
Lordship,
all.
25 years and
Till
also
the
I-
disposal, he should be allowed to continue. Go on.
Matlab,
Till the disposal of the
but
representation.
he will file a representation within 15 days. matlab.
yes.
Uh,
Lordship, 25 years and completed the out of home sector unit tenure. That will kindly be indicated.
What?
That needs to be indicated. Even though their records are set, those two considerations will have to come for posting as a person. Whether they have completed the required number of years in home sector and out of home sector. Out of home sector, that will have to
We will
be.
not go into all this. They'll consider
Lordship-
your representation. You file
Yes,
it.
yes.
till
We'll file. Yes. Okay.
Then in that case, this writ petition has been instituted.
22/5/96,
Challenging the
join on 25/96, 14 years, 7 months, 24 days. At least 24 years.
order dated 18/12/2021,
21 was posted. Impugn order with the first place of the
passed by the Director General. Who has passed
No, passed the order by
Director
Director
General.
General.
Director General.
Yes, CISF,
Who commanded?
by which
Who commanded the command?
the
No.
representation
Director General.
of the petitioner for retaining him in the present unit
He did it.
in the rank of constable or took the fire for remaining part of his service at Bongaigaon,
Bongaigaon.
within the home sector. What do you call it? Home sector or what?
Yes, home
Yes,
sector.
home sector. Home sector. unit.
Within
Home
Assam.
sector. Please stop. Next petitioner. was appointed as constable within Bukit Fire in the Central Industry Security Post by order dated 08/05/1996. The hello, Mr. He has been posted in different places. Finally, the petitioner was posted by, on 6/6/2016 at BGTPP, Bongaigaon, Assam, which is the home sector of the petitioner. Mr. When is the promotion? When is the first posting, transfer posting?
First transfer posting.
After the, no, not first, after Bongaigaon. Impune, that earlier transfer posting.
Lordship, that page 21 of my 29 of our petition. 29.
29. You have
Yes.
challenged this.
We had challenged. Yes, we had challenged this in the first petition.
2020?
18, 12, 2020.
2020.
Which page?
Page
Page
29. my lord.
29 of the writ petition.
Well, the petitioner was serving at Bongaigaon as constable within Bukit Fire. The responding authorities by order dated 18/12/2020 has sought to be transferred on promotion from constable fire within Bukit Fire to the rank of head constable within Bukit Fire on regular basis. He has been sought to be transferred on promotion from Bongaigaon to where?
Bongaigaon to Daman and
Bihar, maybe?
Lordship
Bihar.
BRBCL Navi Nagar.
Where it is?
Bihar.
Bihar, probably, the state of
No, where
BRB.
it is given.
Lordship, the transfer at page 31 is the personnel who have been transferred, and his name is indicated at serial number 17.
To
Posted
In the
to-
list, my lord.
huh?
It is stated here ES.
Huh. Yes, what? How do we know?
What is it here?
Posted to Eastern sector.
Lordship, I'm coming. What is it?
Eastern sector at
It's BRBCL Navi Nagar.
you just tell the name of the
Lordship will kindly take up the document at page 37. The original is in Hindi. That is what we have translated at page 37. It's indicated there in reference to the page 37, annexure 6, in reference to the aforesaid letter has been issued for a CISF number so and so. Posted unit has been promoted, come transfer from this unit to unit of BRBCL Navi Nagar.
to the unit of BRBCL
Navinagar.
Navin Nagar
Navi Nagar.
in the state of Bihar.
Lordship, we are not sure about that. Bihar probably.
You must know Navin Nagar. Please to find out where is Navin Nagar.
Lordship, I'll
Yes,
we'll get the information.
where is Navin Nagar? Oh, just keep it up. In the state of so-and-so. Next page. The petitioner on petitioner has represented to the responding authorities that he is willing to forgo the promotion from the post of constable to the rank of head constable in Wicket Fire on the condition that he be retained at his home sector at Bongaigaon. It was rejected by impugn order or earlier order. Your
Uh,
willingness.
That was rejected by the impugn order here,
Impugn
16/3/2021.
After that, you have filed a writ petition. You
No.
filed a writ petition.
Lordship, first writ petition was filed challenging the transfer cum promotion order.
Yes.
Then
That's what I'm saying.
that is-
Where is that order?
Page 56.
Oh, that High Court order, page
No, no.
56. No.
Page 56. too.
Page 56, yes.
When no
WPC
consideration
429,
was
429.
initiated, the petitioner approached this court by this petition by WPC 429 of 2021. Challenging the transfer of promotion.
Navinagar is Bihar.
Bihar, it's written
Yes,
in
Bihar,
Bihar.
Bihar.
It's in the state of Bihar. This court, considering the submissions of the land counsel to the petitioner, has directed the petitioner to submit to file a representation that he will forego all his future permission from seniority, subject to the condition that he is allowed to continue in the same post of constable in the fire in the same station at DGT EP, Bongaigaon, Assam, for the remaining period part of his service along with a copy of his order. Remaining part of his service. The petitioner filed the representation pursuant to the order of this court. When did you file the representation?
On 16/2/2021
On
at page 59.
16/2/2021.
Page 59 of our petition.
The respondent authority, particularly the Director General, CSA, pursuant to the order of the dispose of the representation of the has considered and disposed of the representation of the petitioner as directed by this court in the writ petition within Wicket Supra on 16/03/2021. And there were and rejected the claim of the rejected the request of the petitioner to retain him in the present unit at Bongaigaon in the rank of constable within Wicket Fire for remaining part of the service. Next page. Hence this writ petition. Next para. MS D. Burgoyne and counsel for the petitioner submits that the respondent authority has not considered the grievance of the petitioner objectively, as the petitioner is entitled to be retained at his home sector after completion of 25 years as per the guidelines. For posting and transfer of CISF personnel by circular number 22 of 2017, dated 25/09/2017. While referring to the clause 12 of the said circular, which provides the tenure of posting, she submits that the first tenure is for 7 years in out of home sector. Second tenure is 12 years in units in home sector. Third tenure is 6 years in out of home sector. And in fourth tenure, within the remaining service is in the home sector. Therefore, since the petitioner has been posted only in the year 2016, and by now he has completed more than 25 years in and out of home sector, the petitioner is entitled to be posted in the home sector, that is in the state of Assam, for the remaining service. She further submits that since the petitioner is willing to forgo that promotion and seniority, the case of the grievance of the petitioner ought to have been considered objectively in terms of the circular which regulates the transfer and posting of the CIS personnel. Next data. Mr. Prasad, Swencha Prasad, the CBSE, on the other hand, submits that at the relevant point of time, when the interim order was passed, and when the petitioner was posted on transfer and posted out on promotion, he has not completed the
25 years.
Rather, he has been allowed to serve in the home sector at Bongaigaon since 2016.
Since
2016.
16.
Therefore, the rejection of the claim of the petitioner, either on forgo of the willing to forgo the promotion or claiming of completion of 25 years, is in accordance with the relevant guidelines and the manuals of the manual which regulates the transfer and posting, etc. of the personnel of CIS. Therefore, the further submits that there cannot be a conditional, there cannot be a willingness to forgo the promotion on condition as the same budget and same is not in accordance with the relevant provisions of guidelines or the rules. The petitioner may forgo his promotion, but he cannot, as a condition precedent to be to retain him in the
Same place.
home posting at the right. Therefore, it's a mistake. The retribution is never to be discussed. Reconsideration will be extensive resolution will be consulted the parties and also it is the materials based on the code. Admittedly, the petitioner is sought to be transferred on promotion from the rank of constable within Wicket Fire to head constable within Wicket Fire. It is also assumed that the petitioner has submitted, he has, it is also assumed that petitioner is willing to forgo the promotion with the condition that provided he is retained at Bongaigaon, that DTCC something like that, Bongaigaon, Assam, which is the home sector of the petitioner. The circular dated 25/09/2017, which regulates the transfer and posting of CISF personnel, inter alia provides that the out-of-home sectors and home sectors tenure for posting in the respect of personnel in the CISF are subject to availability of vacancies from operational and administrative needs and new inductions. The details are quoted here in the page 41. You just write out of home posting sector so and so. Close 12, page 41. You put all close 12, right?
Actually, may I just interrupt once? Just point out one thing. In the impugn order by which they have rejected my representation, what they say is that under the provisions of the DOPT number so-and-so dated 1/10/1991 and para 17.12 of Swami's Establishment and Administrative Manual, the petitioner has to submit only written request of unwillingness for promotion, but the petitioner has submitted willingness to forego his promotion subject to conditions mentioned above, which is not acceptable. Lordship, the Swami's Manual which they have enclosed, it does not say that one cannot impose conditions. Conditions can be seen as reasons for his refusal. Because what Swami's manual says is that
No,
they will.
basically you are agreed by transfer will not look into all this.
No. Why I'm saying that conditions can be looked as reasons for his refusal. Because what Swami's manual says is that the reasons which are adduced by the employee concerned for refusing such offer, that can be accepted or not accepted. One cannot say that that is a condition imposed. That can be seen as a reason.
Basically, you are agreed by
Agreed by
the
the
transfer.
transfer.
You
Yes,
want
yes.
you to be retained there.
Yes.
You will not go into all this thing. Because you don't want to be
Promoted.
promoted. You just want to be retained there.
Written there.
So I'll direct you to that by now you have
28 years.
completed 25 years as per the guidelines. You may be considered. Your
Okay.
representation may be considered. Because it's not a. I
And
mean, we did not go into that. On their reading of the aforesaid provision, above provisions of the transfer and posting guideline goes to show that the personnel in CISF is entitled to be posted in the fourth tenure, i.e., the fourth tenure within the remaining service in the respective home sector district. Where is this 25? Do you calculating this only? 7, 12, and all. What is this? How do you know that 25 years?
25 years. I've joined on in the year 1996.
No, what does it say? It
Page
says
40.
No, it says it talks about first, second, and third tenure.
Yes, Lordship, we are to count the 25 years from the date of initial posting. Initial posting was in the year 1996, 22/5/1996. From there, we have to take into account the number of years completed.
So it talks about 7 years,
7 years initial.
19 years. Okay,
First
19 and 20. Yes. In other words, no, Mr. The first tenure being 7 years in the units in out of home sector. And second tenure 12 years in units in home sector. And the third tenure being 6 years in out of home sector. The personnel has to complete 25 years to be remain posted in the home sector in the fourth tenure. This one. Next one. Admittedly, by now, the petitioner has completed 25 years, completed more than 25 years in the service. The score is of the duration. The petitioner is entitled to the respective home sector. Next step. Having considered about in terms of the circular which regulates the transparent posting of the CISF, the personnel in the CISF. The personnel is entitled to be posted in the home sector in the fourth tenure, i.e., the remaining service. It is certain position of project. guidelines doesn't have the statutory force. At the same time, the guidelines, if it is a professional, is normally has to be followed. Although the petitioner may not have a indefensible right to claim for posting in the posting claim for transfer and posting in the home sector in accordance with in terms of the guidelines, which also provides that the out of home sector and home sector tenure for posting in respect of the personnel are subject to the availability of vacancies from operational and administrative needs and new inductions. Not with comma. Since the authorities have relied on the have been following the circular dated so and so on, circular oblique guidelines dated 25/09/2017 in effecting transfer and posting, and have relied in the impure order, comma, which considered which appears to be a professional, comma. This court is of the view that the province of the petitioner requires to be revisited and in view of the lapse of the time, as by now the petitioner has completed more than 25 years of service. Having considered, no. In view of the discussion made here in above, comma, this court is of the considered view that the province of the petitioner needs a relook by the responding authority. Accordingly, the presented petition, accordingly the writ petition is disposed of with a direction to the respondent or the petitioner to file a detailed representation before the respondent authorities,
Director General,
particularly Director General,
CSF.
within a period of 15 days.
So can it be 20 days because we do not know how he will obtain leave? There to be sanctioned leave also. Those things are there.
Within a period of 20 days from today. This thing. On the thereafter the responding authorities, particularly the Director General CSA is directed to consider and dispose of the representation of the petitioner by taking into account the provisions of the taking into account the provisions of the circular that is 2509/2017 within bracket guidelines for posting and transfer of CIS personnel. The petition is disposal in terms of the above observation and direction.
Okay. Interim order will continue till disposal of the representation.
Till the representation is disposed of. No, the petitioner. No, till the representation is disposed of, the petitioner shall be allowed to continue at so and so mowing of the same. Till representation is disposed
Yes.
of.
Till representation is.
Obliged,
One last prayer, can it
They'll
be?
dispose of within 1 month.
my lord.
Within
1 month of submission, my
50
lord.
days.
Lordship, the representation will be submitted within 20 days
20
will count
days.
from today.
From today.
Can it be from the date of receipt of certified copy, because the Diwali vacations are also.
From today, you will get the order today.
Tomorrow is the opening, my lord.
Obliged.
Huh?
Obliged.
If not, we will get at least tomorrow.
Obliged, my lord.
Dispose of. Yes.
One above Biswas is filed a title suit for declaration and for permanent injunction. In respect of his plot of land measuring 1 bighah 1 katta, Prablachi,
Yes.
situated in village Gauripur town, Dhubri district. My lord, during the pendency, and the petitioner was the defendant, and the petitioner filed the written statement as well as the counterclaim. During the pendency of the suit, the plaintiff filed a petition under Order 23 for withdrawal of the suit due to some formal defects. As he wants to implicate some persons as a necessary party to the suit, and that petition was rejected. The learned trial court held that the impleachment can be done in the course of by provisions of Order 1 Rule 10(2) of CPC. Then, Your Lordship, during the pendency of the suit, the said Babu Biswas, the plaintiff, expired, and his legal representative filed the petition for substitution of the legal heirs, and that was allowed. They have not substituted and they have not amended the plan. Again, they have filed the petition for substitution. Against that, I filed the objection that cannot be allowed, because as per Order 6 Rule 18, they have to amend the plan within 14 days from the date of allowing the amendment. But they have not amended the plan. The learned trial court rejected both the petition, their petition also for the substitution, and also my objection, considering that already substitution was allowed, so the second petition is not considered, and my objection is also not considered by the trial court, considering that the substitution is allowed, so this petition becomes infectious. My lord, this is my case.
Rightly said so.
My lord,
Rightly said so.
my lord, as per Order 6.
Once it is allowed, once the substitution is allowed, what remains? Can
Well,
there be
they-
another
They have to
petition
amend
for-
the plan. They have to amend the plan. And that plan is to be amended within, as per provisions of Order 6 Rule 18.
That's all. Order 6.
Order 6, Rule 18, my lord.
Yes.
Failure to amend after order, if a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted to amend after the expiration of such limited time as aforesaid, and of such 14 days as the case may be, unless the time is extended by the court. In this case, Your Honor, there was no time limited was fixed, and it was not extended by the trial court. As they did not amend the plan, again they have to cover the mischief, their lacuna, they have filed again the petition for substitution of the legal acts. And at that time, I filed the objection. And their petition, subsequent petition, as well as my objection, was rejected by the Venezuela court. Your Honor, the impugned order type copy is page 37,
37.
annexure Act.
Was there any order for amendment?
Yes, ma'am.
Was there any order for amendment?
That, my lord, order 6 Rule 20 is not applicable in this case, my lord.
That is,
that is
I'm
separately,
asking.
completely separate thing.
I'm asking. That's why. Yes, sir.
My lord, page
Was there
26
any order for amendment of the plan?
My lord, page,
Any
yes,
application was
page
sought-
26, my lord.
any order
Yes, my
application
lord.
was sought
Page
for
20.
amendment of the plan?
No, there was no such order for the amendment
Then-
of the
You read again.
They have filed the petition for
18 order rule 18. You read again. Failure to amend after order.
They want to get in place after amendment of the
You read it, please. Again.
failure to amend after order. If a party who has obtained an order for leave to amend does not amend accordingly within the time limited for that purpose by the order, or if no time is thereby limited, then within 14 days from the date of the order, he shall not be permitted to amend after the expiration of such limited period as aforesaid, or of such 14 days as the case may be, unless the time is extended by the court.
Show us any order to amend the plan.
My lord, page 26. Order dated 13/5/22, my lord.
Yes.
Both sides are represented. TDI was fixed for and petition number so and so. On 25/10/2021, the plaintiff has filed a petition number so and so under order 23, rule 1, sub rule 3, Code of Civil Procedure for withdrawing the instant suit with the liberty to file a fresh suit. The plaintiff instituted the instant suit with some formal defect which is not possible to amend at the present stage. The defendant has filed a written objection stating that the instant petition to file a fresh suit is not maintainable as the petition is filed at a belated stage where the evidence of the party is already commenced. Third, there is the case record considering all and the submission made in the said petition, and after going through the objection, the instant petition 303/21 is rejected. The instant petition is rejected on two grounds. Firstly, non-implement of necessary party or change of facts can never be a ground for withdrawal of suit as they are not formal defects. Necessary party can be imputed and new facts can be brought on record by way of amendment.
Yes. Yes.
Hello, so they were given liberty to amend the plan. And then they filed the petition for substitution. As the plaintiff has expired.
Yes. Then,
And that petition was allowed, my lord.
yes. So you are not agreed by that.
Now, I was agreed by the subsequent order.
So you are not agreed by the substitution, order for substitution.
No, for substitution, I was not
Then,
agreed.
where is that, where is the, thereafter, where is the order for amendment? Is there any order for amendment after the substitution?
No, my lord.
Then,
Only thereafter, they have filed again the petition for substitution. Second chance.
so,
So my submission is that when by order 9622, the order was that they can amend the plan. Amendment was, liberty was given to them. And they have not amended, they filed a petition for substitution. And that was allowed. Again, they filed the
see,
petition.
that order was passed before the, when the, before the plaintiff or the plaintiff died.
Yes,
After the death of,
petition was,
after the
that
death of
petition,
the plaintiff was defended
first order was passed when the plaintiff
during
was
the
alive.
lifetime of
And
the
then,
plaintiff.
then they filed the petition for substitution.
Yes, obviously. Thereafter, then
And
we
they have
can-
not substituted, they have not taken any step for substitution. Then again they filed the petition for substitution.
you show us when after the substitution is allowed, what is the procedure? What is the procedure when the substitute after the substitution is allowed?
They have to amend the cost structure.
Under what provision?
They have to, order 22. Order 22.
Show us. Who has to do that?
My lord,
Who has to do that?
to be very fair, it is to be done by the bench color.
Then,
To be very fair.
that is the precisely I am asking. How can you find a fault on that? On the plaintiff or the defendant? Yes. So we need not go into the order 22. Yes, proceed.
Yes.
So it falls.
Order 22 to 3. Procedure in case of death of one of several plaintiffs or of sole plaintiff, where one of two or more plaintiffs dies, and the right of sue does not survive to the surviving plaintiff or plaintiffs alone, or a sole plaintiff or sole surviving plaintiff dies, and the right to sue survives. The court, on an application made in that behalf, shall cause the legal representative of the deceased plaintiff to be made a party and shall proceed with this. Where within the time limited by law, no application is made under Sub-Rule 1, the suit shall abate so far as the deceased plaintiff is concerned, and on the application of the defendant, the court may award to him the cost which he may have incurred in defending the suit and to be recovered from the estate of the deceased plaintiff.
Hmm.
This has been complied with.
My lord,
Order 3 has been complied with.
yes, they have complied within time.
Then sir, what else?
That's, this is my
That's all. Revision petition dismissed.
No way out.
Nothing else. Nowhere.
No way out.
Why were unnecessary wasting,
My lord,
wasting
this-
our time?
My lord, at this stage, I may be given liberty to withdraw the petition.
Better. It's convenient for you or for this court also.
My
Don't have
court
to go into all
Court
this. Except that we have wasted 15 minutes time of them. All of us. Not only court's time, your time also. After arguing the method for some time, Mr. Arkajan,
RKJ.
learned counsel for the petitioner, says that he may be allowed to withdraw the revision petition on the ground that there is no ground to interfere. On realizing that there is nothing, and there is no ground to interfere with the interim order caused by the learned trial court.
My lord, this
Huh?
simply may be, my lord, written that I am withdrawing.
So, we allow to withdraw.
Otherwise, it will be.
Mr. T.J. Manda, learned senior counsel, assisted by learned for respondents. How many?
Two
Respondents is present and raises no objection for prayer of withdrawal. Accordingly, the prayer for the prayer for withdrawal is accepted. Accordingly, revision petition is hence dismissed on withdrawal.
Develop.
Thank you, sir.
Sir.
It's an appeal against an award passed by the member MSCT.
Yes, how much?
Award was lordship will fine. Total award was 12 lakhs and odd,
Yes,
32,000.
yes,
Admittedly, lordship injured claimant was injured.
yes.
His hand was
3
amputated.
lakhs 91,000.
Lordship hand was amputated. Ankle jump.
3 lakhs 91,000, not 2 lakhs.
No, 21 lakhs. 12 lakhs 32,450.
Huh?
12 lakhs 32,450.
Which one?
Oh, sorry. I'm 7 lakhs. Not I'm I think 6 lakhs. I think 7.
391. 391. 3 lakhs 91,000. Yes.
Your Lordship, this matter may be taken, may be adjourned today and taken on 21st of November.
Why? Why
Yes.
special day?
Your Lordship, my senior who is conducting the case is not prepared today with the case
Huh?
due to some his health issues.
You are for
For the
This is-
appellant,
filed by whom?
by the claimant.
For enhancement.
No, Your Lordship, we have filed a review petition before the tribunal.
Yes.
The thing that happened was that while we filed the claim petition, we didn't have the exact insurance.
Actually, I have another case, I cannot tell. So I have prepared that case, and today this case I have not prepared. So let it come in another day. And item number 10,
You are claiming enhancement.
no, not an enhancement. My prayer has been rejected there, and that is why I filed the review.
What?
And my lord, some documents which was provided by the insurance number provided by the police authority, that was false. And later on, DIG and superintendent of the Meghalaya government provided that genuine number. Accordingly, I filed the one review petition, and that has been rejected. But thing is that today I could not submit. I could not read to my
On the prayer of learned counsel for the appellant, that he is not, on the submission of learned counsel for the petitioner, that he is not ready with the case for argument. Come on. Let's forget it. On the prayer of learned counsel for the appellant, this matter after 4 weeks.
on 21st November.
Why not fixing? Anyway, 21st November.
I am sorry, Lordship. I come advance.
It's okay. Oriental Insurance.
Lordship.
Hmm.
Here, Lordship will find total award was 12,32,450. And injury was Lordship above the ankle joint. His hand was amputated. Admittedly, he was a workman of a truck. He was a handyman. The disability tribunal has considered as 100%. The disability should be considered as per Employees Compensation Act, that is Workmen Compensation Act. If below ankle joint one head was amputated, disability is 60%. 60%. Here 100% is considered. That is the case. And we have
Yes. What do you say?
Lordship, there is no perversity in the judgment because the
See, there is a provision.
yes, Lordship, that is Employees Compensation Act, but the compensation has been awarded considering his nature of work. Lordship, he was a handyman, and he was not so educated that
Nature of the injury, it's not 100%. To that extent, we are modifying 60%.
it is up to your Lordship.
Not up to me. You just argue.
No, Lordship, my
This
point
is
of
my prime question because it is to be 60%, not 100%.
yes, Lordship.
We'll
but
modify to the extent of
disability
60%.
has been assessed.
You just calculate how
we have
should it
given
be.
a chart of it. Calculation has been given.
If it is 60%.
Look,
Yes.
the first phase, Lordship, recalculation has been there at the next phase.
Assessment of compensation by honorable tribunal, and then
Then, Lordship, recalculation of the award as per
according to you, if it is taken at 60%, right?
Lordship.
Monthly income,
That will be
360.
8,28,098.
huh?
8,28,098.
Where you have given
Next page, Lordship, the chart.
60%.
Next page. Recalculation as per MD Act. Lordship, got it?
Hmm.
If filed in the WC Act, then it will be more reduced. But in case of MSCT, they have this option claimant has filed in the MSCT case. So it will come to rupees 8,28,098.
Yes. Now, then if it is calculated as per the employees' compensation, it comes around 3,98,000.
98,000.
You are not on this.
Because he has
Yes,
not
yes,
filed under
yes.
WC Act, he has come under the
It is an
MSCT Act.
MSCT, therefore, according to it's 8,28,000.
8,28,000 is considered 70,000.
And which will not 5%.
It is should be 60%.
No, 60% where you have calculated here.
Lordship will find loss of earning capacity at rupees 10.88640 per income plus 70% disability as per schedule of the WC Act.
Why you have said 70%?
Lordship, we have noticed, we have taken the photographs of the what is the ankle joint, what is the head.
Okay. So you said 60%. Now you are
60%.
saying you have 70%. You have
Lordship, we will
calculated-
calculate it should be 60% as per schedule. Because Lordship, biological word generally we don't understand. After taking photographs from the
So we'll go by 70%, not 60%.
Lordship.
Yes. What was the interest awarded by the
5%.
tribunal?
5% per annum.
5% per annum.
We'll make it 6.5.
Lordship.
6.5. Interest 6.5.
And there should be interest on the
6.5
Lordship.
from the date of filing of the claim petition till realization.
And there should not be interest on future prospect.
Huh?
There should not be any interest on future prospect. Amount has been awarded considering future prospect also. It is already settled, no interest on future.
Lordship, that future prospect has been assessed relying upon the judgment of the Honorable Apex Court, Lordship. That should not be removed, Lordship.
No, future prospect paba to interest not.
Interest.
There will be no interest on the amount under the head of future prospect. Lordship will kindly see 40% has been considered as future prospect.
The equity paid is the amount of compensation is limited. No, this is 5% interest from the date of filing.
Date of the filing of the claim petition. Lordship will
So
enhance.
you are enhancing it 6.5.
6.5. We'll get 6.5.
Would not say anything about other things.
No, future prospect Lordship, it is settled. Supreme Court has already settled and this High Court.
If it is settled, why we should be we will say?
No. You will get 6%.
See, only the modification is 100% from to 70%, right? And then the enhancement of interest
6.5.
6.5%.
On the total award, not on the amount awarded under the head of future prospect.
Yes, total amount.
Total amount.
We're just enhancing 6.5% to 6.5, and then reducing that 100% to 70%.
70%.
That's all.
It should be 60%, but it should be Lordship. I have agreed 70%.
No, it's okay.
Only Lordship will observe Lordship. There should be no interest on amount
We're
under the
not saying anything.
Lordship. That is the law, Lordship.
We're not saying that if it is the law, we did not reiterate again and again. We're not touching anything. We're just saying
ultimately
modification is to the extent of 100% from 100% to 70%. Interest increasing, enhancing from 5% to 65%, 6.5%.
I'm also not objecting to that, Lordship.
That's all.
Only Lordship will observe.
We're not saying anything.
Lordship, have to note it down 2 things, Lordship. We have deposited 50% of the award before the registry as per interim order. That should be adjusted, as well as the statutory amount. Statutory amount deposited by the insurance company at the time of filing appeal, that will be adjusted for the final payment.
You have deposited 50%.
50% as well as 25,000
Yes,
sir.
50% already deposited.
Will be
Should
adjusted.
in the record by adjusting the 50%.
And 25,000 is statutory amount. That will be adjusted and it will be released to the claimant.
First, you have to deposit
We have deposited
all.
already 25%, 25,000 as well as 50% of the award. That will be adjusted with the final payment.
Obviously, that
Otherwise, Lordship may forget. That is why
50% amount deposited
will be adjusted from the final award.
and 25,000 deposited by appellant shall be released
Adjusted.
to the
Adjusted.
claimant, and
Balance amount will be deposited
balance
by the
amount will be
deposited by the claimant. By the appellant. Balance amount will be deposited by the claimant with interest. That should be recorded. Otherwise, Lordship may forget. Lordship. That is why.
Okay.
And on the amount of future prospect, Lordship, that should be Lordship record as per judgment of the Supreme Court. No interest on future prospect.
She will not do it. She knows the law.
That is the law. That is why, Lordship.
So we're not saying anything. We're not saying anything on
No,
that.
if Lordship will not say anything, then we have to pay Lordship. That is the law. Only the amount under the head of future prospect.
Why you should pay? Why you should pay against the law?
No. If as per judgment, you have to pay Lordship. As per judgment, you have to pay.
We'll see.
Lordship.
I'll see.
No interest on future prospect. Otherwise, the whole amount will pay from the date of the filing. Only on the amount.
With interest.
Only with interest, except the amount awarded under the head of future prospect, only on the ground that future prospect is reasonable in future. On future amount, we are paying interest at this stage from the date of the filing of the claim petition. It is not logical. That is why Supreme Court has said no amount under the head of future prospect there will be interest because it is.
Where is that? Where is that judgment?
I'll give the judgment also.
Just wait, I just wanted to, what is that?
Michael, look. I'm giving copy of his judgment also after 5 minutes. It will be a small amount, but it is only 1,440 research prospect.
Have you shared this copy with her?
Let's see. I am not giving her. She says not accepted.
Look at this recalculation. Next page. Second page.
This is my income tax is 600. 40% future prospect. 40% this total. Multiply.
You have reduced it to 40%.
Future prospect is 40%. Future prospect is
Tribunal has given it 50%.
50%, but it should be 40% as per Pranay City.
Pranay
City.
Pranay City. Yes, madam.
Calculation would be 70%, 60%.
Change would be 50 to 40.
Yes, Lordship.
Pranay City
As
cannot
per,
have more than 40%.
if it is as per law, then Lordship is.
No, you must tell us.
It's all right, Lordship.
We are recording your submission. You have no objection. All right.
Objection
That is the
that-
law, Lordship. That is the law.
Objection is that, Lordship, there is no hard and fast rule that disability has to be calculated at this person, loss of future earning capacity is that person. It is up to, it is the discretion of the learned member of the tribunal, Lordship. And the claimant, he was a handyman, Lordship. So he is not that much educated that he will get a job where no physical labor is required, Lordship. So if his right hand has been amputated, he is permanently disabled to do the job which you are.
Perhaps you are arguing against the law.
Lordship, it's up to your Lordship.
No, it's not up to me. It's up to you, in fact. You are the claimant. How much you want? You are happy with this?
Lordship, it is as per law, then
I don't know. To the extent. Now these three components. Future
future
prospect
suspect.
50% to 40%
Yes,
in view of the chronicity. Then that
Loss of earning capacity is
loss of
70.
earning 100 to 70, and the interest will be enhanced from 5% to 6.5%.
And no interest on the amount under the head of peace officer. No interest on the amount under the head of peace
One
officer.
more.
I will give the judgment also. That is the law, Lordship.
That is not the issue you are raising.
No, we are raising, Lordship. We are raising that. That is the law, Lordship. I am giving the judgment, copy of the judgment just now, Lordship. Lordship may take after.
We'll see. Yes. Next.
Oblige. Lordship, I am agreeing with this.
Yes.
Withdrawing the case, Lordship. As per instruction, I am withdrawing the case, Lordship.
Is it?
Yes, Lordship.
Heard Mr.
D.
No,
Barua.
Mr. B. Barua, learned counsel for the petitioner. Submits that he has an instruction to withdraw the petition.
In fact, he has no grievance, Lordship. That is
Therefore,
infractions matter, Lordship.
therefore, he may be allowed to withdraw the petition.
Lordship, I am appearing for 1, 2, and 3, Lordship.
Ah.
N. Upadhyay for 1, 2, and 3.
SG Gurua for respondent number 4.
Just one moment. Are present? Listen. The writ petition stands dismissed on the withdrawal.
Obliged, Lordship.
Yes, madam. That the
Yes, ANL matters.
yes,
Yes.
that I find that it has been uploaded. Order is uploaded.
My lord, I have to see another thing because
Yes. That in that series of matters.
series because I see.
There's no nothing particulars has been given in the petition.
My lord, there is
You
one.
only said that on
My lord,
order
there is
you have,
one.
you have already submitted that they are working in ANM.
Yes, my lord.
I don't find anything
My
in the
lord, there is
petition.
one inside the petition. There is one draft made, my lord, in the petition itself.
I could not
in
locate
the-
that. In any way, I have already disposed it of.
My lord,
Because I was not that.
I have typed it in a form of draft, my lord, in the form of draft, giving their rank and designation. In the petition itself, my lord, I forgot the
I could not locate it.
My lord, inside,
Anyway, I have already disposed of.
my
But I
lord.
was not happy that at least this,
my lord,
in which post
in
you are
paragraph
working.
number, my lord, 2, I have given the descriptions as far I remember.
Maybe I might missed it, but
My lord,
I
I
could not.
will,
I
in
could not.
paragraph number 2 and inside one
Anyway, it
draft.
should not be a problem.
Yes.
Otherwise, the particulars needs to be given.
Obliged, my lord.
Good one will be- Alright. That MSc. I think this is what? I don't know. Yes, it is.
Before the main hearing, there is a petition filed by the other particular. I think that has to be disclosed.
The appeal is for enhancement.
Yes.
Only on 2 grounds, my lord. The award was, my lord, for $37,66,378. And enhancement, my lord, we are paying for enhancement
The case,
only
case of death.
date, case
Death
of
case.
death. Case of death. At the time of the accident, he was the deputy ranger of Forest Department of the state of Assam. And my lord, we are on 2 grounds specifically. One is, my lord, multiplier was wrong multiplier is adopted. And other is, my lord, additional 10% was deducted from the salary. Total amount of compensation, my lord. That is the main two ground, my lord.
Yes. This IA has to be, madam, what is to be done in IA?
We do. Cross objection.
Cross objection.
Cross objection was filed by the owner as well as the insurer.
Yes. So once.
I is required, my lord. I have filed this. I am the driver and owner. private component. And I have filed this because I did not receive any notice from the tribunal. And that is why I have submitted this IA for taking cross-examination at appellate stage. But before that, let it submit, then I am coming after completion his submission.
The liability is fixed on you.
Yes. But because, my lord, what happened in that before tribunal, I was not served any.
Liabilities is fixed on you.
Yes, yes, liability has been imposed on me, but that should go to the insurance company on merit as well as, my lord, as I have not given the justice to serve the notice.
So this cross objection is also by the insurance company. Madam, you have
Cross
also filed
objection,
a
insurance
cross-
company.
filed a cross-
We are given pay and recovery. But what we are saying is that there is no proof after the amendment.
You will consider. Yes.
And what happens in this case, while the judgment was passed by the learned tribunal on 12/3/2020, my lord. It was a death case, and my lord, while the claimant has examined 3 witnesses, including herself. My lord, we come to the My lord, my lordship may kindly see page, my lord, 17, my lord.
17.
17.
Yes.
My lord, that is the issues.
There is no page 17.
Page 17, my lord. That is, sorry, my lord, 11, my lord. 11, my lord. 10, lordship may kindly put paragraph 10, 5, my lord. Sorry, paragraph 15. Paragraph 15, page 10, my lord.
Yes.
Paragraph 15, my lord, may I read, my lord?
Yes.
The claimant in the claim petition has stated that the Bhadraswamy Mali died at the age of 54 years. PW3 Gundeep Das has deposed in his evidence that the date of birth of the victim as per office record is 1/10/1963. Accordingly, it is held that at the time of accident, deceased was 50 years plus and was in between the age group of 51 years to 55 years. Hence, the appropriate multiplier shall be 11 for ascertaining the loss of dependency in the instant case. So they have, the learned tribunal has adopted the multiplier of A11. In my humble submissions, my lord, that is wrong. That is wrong, my lord. Because, my lord, here in this case, my lord, lordship may kindly come to my page 4, my lord. That my ground number 2. Because considering the date of death and the date of birth, as per his service record, my lord, he has completed 50 years, 1 month, 23 days.
Yes.
My senior is here, my lord.
Only on for announcement, my lord, on the ground of calculation mistake, my lord, because of the one is days, no? So in that case, my lord, there probably their application has to be had in them. They have had a miscase.
Think what?
Cross
Cross objection is there.
No.
IA
That he said it is between, my lord.
Yes. That is my IA for additional, my lord, taking cross-examination of the evidence at appellate stage. IA number 2116. 2116.
2116.
Yes.
Yes.
My main submission is that it will lordship go to the record of the lower courts, my lord, tribunal. It will change, my lord. I have not been served any notice from the tribunal,
Yes.
and that is clear from order dated 8/3/2018. Your lordship, LCR.
Okay.
Yes, your lordship, I draw your lordship's notice to lower courts record, Tribunal's LCR. LCR is there.
According to a notice was not served on you.
Notice was not served.
You want to have a
So, my lord, that is one submission.
at this stage,
Yes.
appellate stage.
Yes, appellate stage, it is
To prove the
applicable
driving license.
to the license for that period. For when one sided, I have my submission is twofold submission. One is I have not been served the notice. Another is there is on merit also case is clear, my lord. The period when the accident occurred, that period has not been proved at all. And record it is clear from the statement records of the insurance company. From the records of the insurance company, it is clear that they have not proved anything which proves that my license was not valid at that period. So LCR, your lordship,
What is the findings of the tribunal on that regarding the license, driving license?
yes, page para 26 and 27, your lordship of the judgment. In appeal, MSc appeal, page 12, page 12, 26 and 27. Here,
Yes.
Yes, Your Lordship, in
Let us-
LCR,
let
Your
us-
Lordship,
Let us see how you are, whether you have served with the notice or not.
yes, that is,
That will be crucial.
yes, yes, yes.
Yeah, what it is?
One is first order dated 7/5/2014 of the LCR.
Can you mark it and whether notice issued, whether it was served or not? It just shows that if you are not served, you'll allow.
Yes, yes. No,
If
I
it is
mean,
served,
yes, yes.
if it is served,
Yes.
it will be dismissed, rejected.
No, two submission, two-fold submission. One is notice was not served and another is on merit. So on merit I am coming later on. So
No, so far as this IA is concerned.
yes, yes, yes. Sure, sure.
Because you are seeking additional
Evidence.
at this stage.
Yes.
So if you find that you have notice has not been served,
Yes.
then we will allow this IA.
Yes. Yeah.
You just let me find. You just saw, madam, both of you that whether it is served or not, that indication. Report.
7 interpretation. 7/5. I got 8. 7/5. Okay.
Sir, maybe because of this, it's off the record. Not relevant to that. Maybe because of the Dantaras, why all of us look so gloomy? Everybody is want to go home early.
Yes, yes.
Of course, you are having a reference today, but then
There's a reference to it.
today nobody is looks cheer up. Everybody
Because
is
of
looking-
melody holidays. That's why, my lord, I thought that, my lord, his case will be placed today and my case will be when a main case will, because I am happy if it is burden shifted to the insurance company.
Yeah.
He is a private party. Because in that, after the death, my lord, till today, I am not getting a single penny, my lord. My husband died, he was a ranger, and till today, nothing happened in this, my lord. And that was a wrong calculation. I am only on calculation, but my party is that, my lord, it is already judgment is there, that is clear. But now they say that, my lord, if it is shifted to, my lord, burden shifted to insurance company, I'll be happy, my lord.
Because it's very difficult to.
Yes. Otherwise,
Take out
it will
from
be
the
very difficult to,
individual.
my lord.
Well, can sort of. He must be a big man. Will not let him go off.
My lord. No, that's
But
already.
in accordance with law.
Yes, yes. Already, my lord, there is a order to give the money by the insurance company. And insurance company will recover from him. But that is also not complied till today. And because of the pendency of this appeal for announcement.
My lord,
Yes.
26/7/16.
Yes.
It was directed to take the fresh step. Earlier, they have taken steps, but that was not served.
Yes.
In 2014, they have taken steps, and 26/7/16, they have it was asked to them to take the steps, fresh steps, and 8/3/2018 order, 8/3/2018. After this 16th order, my lord, 26/7/16, no steps has been taken, and 8/3/2018, from the earlier, my lord, steps which was taken in the year 2014, on the basis of that, court has presumed that notice has been served. In 14, they have taken registered steps, and as per their, my lord, someone has appeared on behalf of me on that period. If it is appeared, then court should not have, my lord, passed this 26/7/2016 order. In 26/7/2016, it was redirected to take the fresh steps, but they have not taken steps within 2 years. And 8/3/2018, court presumed the notice has been served on the basis of the steps postal receipt which was taken in the year 2014.
Yes.
So it is clear, my lord, no notice was served. And thereafter, my lord, expertise proceedings continue. So it is clear from the, yeah, if you continue, then continue.
The yellow marking lordship.
Yeah.
The petitioner, he appeared, he filed petition, Wakalatnama is there, so there is no question of not receiving the yellow marks are also and as well as the Wakalatnama, as well as the postal receipt. I think Clement Advocate can pass through that because they showed me that.
So, my lord,
Already served and he appeared, filed petition, after that he chose not to appear.
that if it is so, my lord, our submission is correct, then court should not have directed to take the fresh steps.
Forget about that.
Someone has appeared, I do not know. Someone has filed Wakalatnama, but I do not know whether any person was appeared on behalf of me or not.
2nd of August, you filed a power.
Yes, power is there.
You filed a petition
Yes.
also.
But something is happened. Something is happened because that is why court has redirected to take the fresh steps in 2016, 26/7/2016, court directed to take the fresh steps. Something comes to the knowledge to the tribunal. That is why 26/7/2016 order.
What's something, sir?
I do not know.
It was directed.
I do not know, but I have not said because I was out of station.
It's the opposite parties are present. What do you mean by that? The claimant is directed to take fresh steps for issuance of notice.
Maybe insurance, opposite party.
Obvious to registered AD with post with AD immediately.
That opposite party may be insurance.
There's no report, service report. There's no service report.
No, there is no. That's why they filed the petition as well as the.
No, this is the Wakalatnama is of 2nd August 2014.
They already
And
appeared.
on 08/03/2018, it is presumed to have been served.
Because
Only on the ground that it has been issued to the notice was issued by postal receipt. It
The
says
report
about
is not there.
issuance.
Report is not there.
Service is not
when
reflected.
they already appeared, there is no question of.
Then why the court tribunal has to record this? If they are already appeared,
Yes. So that is tribunal's mistake. But then his submission on affidavit, on oath, that he did not get notice and that he did not appear, that is not correct.
no, it's correct because issuance of notice is one thing and serving is
No, Lordship,
quite
because he
the other
filed the
thing.
petition filed the petition, filed wakalatnama. After that, you chose not to.
No, that's what I'm saying. But why this 26, after they have filed the wakalatnama in 2014, 16 court tribunal has recorded that notice has press is still to taken.
That
Accordingly,
payment advocate can explain also.
accordingly on 8/3/2018, it is recorded that on 7/6 notice was issued by postal receipt, whatever. But it doesn't indicate that whether it was served or not. It does not. It talks about only issuance only.
So that is the second time. But already the gentleman was on record. He filed his.
No, that's what I'm
petition.
saying. Why? If he was already on record, should have been recorded that in spite of appearance. How do we decide that? We'll go by the order of the tribunal only. Because it indicates only the issuance of the notice in 2018 and wakalatnama is in 2014.
Yes, because he received the notice. Maybe the court found that already the parties are on record. Maybe that order was.
Why this different order? It doesn't say.
And moreover,
Language is very clear. Notice was issued on 7/6/2014. Right?
Notice, postal report, I could not, postal
But
report
this-
that is there, Lordship, I have asked
Your
with yellow mark, but there is one postal receipt, Lordship. Because we had
yes, I've seen it. And this is also wrong when it was.
And
When
when-
is 7/6/2014?
When there is no report, then they should have called the peon to take the evidence, whether that was served or not. That has not been done.
What
As
is
per
it, seven?
CPC. As per CPC, that means.
taken time, that is there, Lordship, order is there.
What is the notice issuance of notice on 7/6/2024? 7/6/2024 final. Let's go 14, sorry.
40.
7/6/2020. The 14, sorry. 7/6/2014 notice with postal receipt. No, 8/3/2018 order, it says 7/6/2014. Notice was issued.
Another notice, Lordship, is something that I have marked in my account for Lordship. It is. The date is 22/2/18. 22/8/18.
Let us have it some other day.
To add to my lord, my another
When?
fixing some other day.
When you agree that
It may have taken as mark Pata.
Over 18, that is what I don't know, but Lordship, the postal receipt is there.
But then- but then-
22/2/18.
18.
Yes, it has been filed on 2/3/2014.
No, it's indicate 8/3/2018 order indicates that notice was issued on 7/6/2014. What is that notice? That plague one. Last order. What was deemed to be served. Deemed served wala. 08/03/2018 order. It is plague. Last plague, red one. It says notice was issued on 7/6/2014. Where is that notice?
But that only claimant can explain this part.
How can I explain my
No, if, because
How can I
that is
explain?
taken by them.
Now we'll go by the record now.
Oh, yes, yes.
What is to
I'm
be
ready for
decided?
the hearing on the.
Yes, any other day.
Yes, your lordship, keep it fixed, part her item on,
No,
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 not
partner.
part.
Partner will be very difficult.
21, others will thinking, okay, yeah, they'll.
No, first we'll decide. It will simple.
Yes.
We'll go by the record. If you are served, you will not be allowed. Your IA will be rejected.
Yes.
If you
On
are
this
not
point,
served,
yes.
you will allow.
Yes.
Then it may prolong other than taking evidence if it is
Next
allowed.
week, my lord, is possible.
It's already considered.
On 15th,
15 is holiday.
15th for,
If you want to have before me in the guest house, I'm ready.
Already, I have cases.
Next week.
No, make it after.
Any day.
But after 15, the week starting 18.
On the prayer of blood is concentrated.
19.
Parties, let this matter be listed on 19.
19.
Insurance company. Here, Lordship, one problem is that Lordship, state is a party in this case. I mean, Assam State Transport Corporation, my lord. Notice has been duly served, but they have not appeared because the liability is approaching between the ASTC vehicle and our vehicle.
Okay.
So my prayer is that they may be. They should appear, Lordship.
You are for?
I am for claimant.
Who is appearing for? Who is the standing counsel?
Name, specific name is not shown in the cause description.
Respondent number?
6. Otherwise, notice has been duly served and they had appeared in the trial code also.
Managing Director, Assam State Transport Corporation. Liability is also fixed on him.
50-50 also. 50. Our stand is against the fixing liability upon us. That is why we have preferred the appeal.
Is it liable to the respondent number 6 only?
No, liability is on respondent number 6 as well as the appellant. That is us, Lordship. So we are challenging. We are challenging the liability part, our part.
Saying what?
Saying that there is no recent negligence on our part. This is our ground of appeal. Challenge the quantum.
Recent negligence on the part of the driver.
Driver of the ASTC bus as well as our driver.
What about other respondents?
Notice served. Lordship.
Third Mr.
Equally.
Name is counsel for the appellant and Mr.
80 shortcut. 80 shortcut. For us, one.
And counsel for
1, 2, 4. 1, 2, 3, 4. 4 planes.
non APS for respondent. Let's go. Non APS. We have response 6 and 7.
6 and 7, they have the 7 is not required, Lordship.
8.
Because it also not required, but presence of 6 might be required because they have the liability, Lordship.
Non APS for the respondent 6, 7 and 8. Dispatch service of notice. Next one. Considering that the respondent number 6 for determination of this appeal. Respondent number 6 the presence of respondent number 6 is required. Let this matter be listed after 3 weeks. This fundamental land council for the FLNC applies the council for the respondent number 6. You cannot tell him.
So far my information was they have standing counsel in the High Court also.
Yes. They inform him. Whoever.
I will inform you.
And registry may be directed to the name of
Oh,
the
that
respondent
will
number
be
6.
lordship, better lordship. The registry will be directed
To reflect the name of standing counsel for respondent number 6. That is managing director.
ASTC.
No, ASTC. Assam State Transport Corporation
Transport Corporation.
Limited.
Much older.
Yes. No, I'm not there in this case. Yes, you are for?
I am for the claimant.
What is to be done?
My lord, in this case, nothing is survived, my lord.
Yes.
Only question raised regarding the
Who is KK Bhatta?
see, my lord, he's
I've not seen him in the court, my lord, today.
but his juniors are also there.
Not appears for the petitioner or appellant on call. Although the name of the Mr. KK Bhatta is reflected to be the counsel for the appellant. Then you are
Respondent number 1,
Ayat
Ayat Talukdar.
Mr. Ayat Talukdar. Ayat Talukdar and counsel for the number 1.
My lord, the short date may be fixed, my lord.
Let this letter be listed after 2 weeks.
My lord, can you leave 19th of November, my lord. 19,
2 weeks.
19, my lord.
On 19
November.
11 2020.
Obligation.
Lordship, you kindly pass over this matter for the time being, Lordship.
But
now,
we are rising at 3.
my lord, let it be, my lord started. Why? I don't know why it will be
Actually,
possible.
he's in the mediation center.
Then may start, my lord, in the meantime.
There is 2 appeal. One is held by me.
Okay, he can start then. Item number 15, he can start.
What is the
Item number, in this case, item number 14 by the insurance company and 15 by the owner of the vehicle.
owner of the vehicle? By that.
You can take up item.
Some other day. How long it will take?
No, it is limited.
Rising,
My
right?
case is very simple.
Rising at 350.
Small case, lordship, single
My
point.
case is simple point.
What?
Because we have the insurance. The fact is that we have purchased a vehicle on 29/1/2019. Dumper. Next day, morning 13/1/2019, the empty vehicle proceeded to a garage for fitting this accessory. Then meeting accident. Empty vehicle. Insurance is there. It is admitted. But the tribunal said that it's a commercial vehicle, permit is required. It's not there. There is exception is there. As per law. Therefore, directed the insurance company to pay the amount and it is recovered from the owner. That part. Therefore, I find this very modified. There is no liability on the part of the owner. And it is also not denied by that.
You are
Owner of it.
owner of the vehicle. So according to you, there's no liability.
There is no liability on the
can
owner.
be fixed on you.
Left.
Why?
Why the permit is not required for the empty vehicle in this dealership and it MSC still the Motor Vehicle Act.
Yes.
Can this item be taken up next week? I have some health issues. I am not feeling
Why
well.
fix so many cases? Then after 2 weeks.
My lord, many dates, my lord, case is adjourned, lordship. The petitioner,
Not because
the
of me.
claimant's
It is
lordship,
because it did not
the
reach
claimant,
out.
my lord, suffering from, my lord, kidney problem, lordship. The money is required.
Just immediately
My
after
lord,
Diwali next week.
Many dates, my lord, the adjournment is, my lord, taken at the instance of my lord, friend, lordship. Next week, a date may be given, lordship.
That may be given, Lord. So I don't. Otherwise, I have never refused in this court. I have never taken time.
Dada, both time.
No, no, eight court of not time.
It is not, no, I'm not in this court.
Mr. R. Goswami. R. Goswami.
Yes, yes, Lordship.
For the appellant in the MSC Appeal 332 of 2021. Is this matter on 7, 12,
Make it
Loss.
12, 11, 20.
Alright.
12 is hearing date. 12 years. Yeah. Mr. SU.
Yes, Islam.
S. Islam. Manufacturer Appellant. In MSC April 285 2020. And Mr.
M.H. Ahmed.
M.S. Ahmed.
Lordship. Respondent 1 to 4.
Are present.
All right.
Why 16, 17?
Well, in this case,
I'm on behalf of 16, Lordship.
item number 17, my lord, this is a cross appeal filed by the owner. We were, on the last occasion, we came to learn about the filing and the IA and the appeal memo were served. We need to file our objection to the cross objection here.
Cross appeal by, in?
By the owner, my lord. So item number 17, my name was not, name is also not reflected in the call list.
You are for respondent. You are petitioner in
Number 17. I am appellant on behalf of appellant, Lordship. That is item number, in the item number 16, Lordship.
17, who is for the appellant? 17, who is for the
One
appellant?
Mr. Biswajit Burma had filed, Burman had filed.
Yes,
this appeal.
Burman. And some Goswami. They have
Why,
filed.
the filing, why filing number is not given?
My lord.
No, only filing number. This
Because, my lord, there is a delay, my lord. IA is pending.
This case is
I is not listed.
filing the appeal, they have delayed.
I is not listed.
It is listed, my lord.
Listed.
Where it is?
Item
Item IA 669 2020. Yes.
It is not listed. It's not listed in, it is shown, not shown in the post.
Maybe, my lord.
This has been dismissed.
It was a restoration application. And thereafter, my lord, the other day, my lord, it was restored, I believe.
IS 669 has been dismissed for non-prosecution.
So far, my knowledge is concerned against the dismissal of the IAS, they have filed another case.
Yeah.
And
Yes, I guess 7th or 14th. It may prepone also.
Huh?
Last day, I just checked 12th end of the year. 7th or 14th.
Make it 14.
14th.
Okay, now. Yes, those IS are
My
not
lord,
listed.
let me clarify, my lord. There was a delay in filing the cross objection, my lord.
Yeah.
That condonation application was dismissed. Against that, a restoration application was filed, which was registered as miscase MC 68 of 2023.
Yes.
And again in the restoration application also, Malad, there was a delay, which was numbered as IA Civil number 2888 of 2024.
It's not listed today.
Yes, ma'am. All this application has to be on board, madam.
It's good. Thing was.
If I'm not wrong, Malad, the restoration was allowed on the last day. Hmm.
No, the IA has been allowed.
Yes.
In this case is what?
Now the Lordship will take up IA Civil 669 of
No,
2023.
this has also been
Disposed of.
disposed of.
Then, my lord,
Disposed of.
the
Now only it has to be numbered. Appeal has to be numbered.
appeal has to be numbered.
Yes. This is by Puturam Borok.
Yes, Your Lordship.
Who is the
The owner of the vehicle.
Appellant. Who is the appellant?
Appellant,
He's
I am on behalf of appellant, that is the deceased.
In item 17. Will you say? I will see. Not Mr. The learned counsel for Mr. M. Goswami. Learned counsel appearing on behalf of Mr. M. Goswami.
Just
Counsel for
note
the
the orders
appellant.
vote office. This is again restored back.
In here, huh?
So this we
Item
have to file
17.
objection.
Item 17, right? In view of the order passed in no. Yes, the delay for filing appeal has been
Restored back.
restored.
Yes.
But there is no
No, my lord. Now we will file our objection to that condonation application.
no since then in the IA, huh? IA 669, right?
My lord.
In view of the order passed in MC 08 of 2024, restoring the dated 24/09/2024. Just in view of the order dated 24/09/2024, passed in MC 68 of 2024. The respondents are granted 2 weeks time to file objection to the IA, objection to the interlocutory application. It will be in IA 669. Legally. Unnecessary. In that case, in view of then you just write, then then what order should be passed?
I think, my lord, it should be deferred today. Must be. That will be a better thing.
You write. This is the IA
669 2023 maybe.
669 2023 listed, which has been filed for condemnation of delay in filing connected appeal. Let this matter be listed after
2 weeks.
2 weeks listed. Registered to list the IA 669 2020. That's all.
Okay. That will suffice. In item 16.
16, 17.
Yes, sir. The date may be fixed, Your Lordship.
It will be done after 2 weeks.
Any date after 2 weeks.
Just note down.
22/11.
there is some inconvenience on 22nd.
Thereafter, 23rd.
Well, after 24th.
25 is motion day.
27th will be better.
Then motion day.
26th.
26th, yeah. It may be.
26th.
This should be listed for orders only.
Yes, it will come for orders on.
25.
27th, my lord.
That is motion day.
Motion day, Your Lordship.
27th.
No,
It will come on hearing day, Your Lordship.
no.
No, it will come for the
Because
orders because it's already packed, na?
this thing has to be, first it has to be condoned,
Lordship.
and then it should be numbered,
Lordship.
then only you can fix it for, take it up for hearing.
Obliged.
Highly obliged.
I'm sorry for the mix-up, my lord.
Yeah, it's okay. It's not listed. Problem is IAs are not listed.
So,
Yes.
removal from service, Lordship, pursuant to disciplinary proceedings. And there was a criminal proceedings also on the same set of facts and the same set of evidence, wherein the petitioner has been acquitted.
Yes.
Now, there are procedural as well as substantive defects in the entire proceedings. The inquiry report, it has not been prepared in accordance with the manual of departmental proceedings. No findings recorded. How the government advocate is supposed to be here.
Which department?
Lordship, it's government advocate appears here. Police, Lordship, he was in the home department. Just after 5 years into his service, Lordship, the petitioner has been removed.
How long you will take?
Lordship.
How long you will
Yes.
take?
You, let's see. Sometime will be. You're the government advocate. To the government
Huh?
The government advocate is coming. That is what is. I can proceed.
No, and we're raising at 3:15.
I'll complete by then. I won't take much.
Whatever the government.
This one let's in another court.
Can it be taken some other day?
Lordship, some other day. As
In
per-
any case, you may complete by 3:15, but it may take another time. How long you will take? 15 minutes?
Not more than, Lordship, probably 20-25 minutes.
In that case, 1 hour will be there.
Huh?
Some other day, in that case.
Lordship, as per convenience. As per,
Because 30, we have
as per convenience of the honorable court. It is 20.
because if you cannot complete, it's no point.
Within half an hour, 20-25, I'll complete. But I do not know how much time they'll take.
Buildings are completed.
Readings are complete. And since it is a matter of disciplinary proceedings, the affidavit is also not of much relevance here.
But
The
we'll have to
inquiry
see the report also. no?
record they have brought, because on one of the previous occasions, that is what was submitted, that the records are here.
No, that's what I'm saying. Record, you will have to examine the record also. You will have to refer to the record also.
Record, probably, because otherwise there are very glaring Lordship procedural defects here. And not only on procedural, yes, on merit also I'll be relying. And the law, as your Lordship knows, it's very much clear in case of how it has to be dealt in case of similar criminal proceedings. On that point, because of those points, Lordship, this will not take much time also, as in case of other disciplinary proceedings cases.
Which judgment you are relying?
Lordship, 2024 1 SCC 175. Ramlal's case. Recent judgment.
Ramlal.
Yes, it's recent judgment that was passed.
Okay. Mr. Is he coming?
He's on late, so phone is not receiving me.
Lordship, the first show cause notice which was issued at page 34.
Do you have the brief? Have you gone through?
No.
Who are you?
I'm panel advocate, Lordship.
Yes.
I'm not attached with university. Therefore,
You are not ready.
Not ready.
You have not gone through the file.
Not going to the file.
So probably by the time halfway.
This
Yes.
Burgohai, that was not a piecemeal kind of thing. It is.
As your Lordship please. As your Lordship.
Otherwise, I can hear you, but if he says something, come and text them, it will be unnecessary.
Understand.
First week of November, any date? Huh? Date may be fixed one.
After a week, yes. After a week.
After a week, but we have picked so many matters.
Hearing date, hearing date.
13 is.
No, a motion date. 13 is a motion date.
Hearing date.
Hearing is 14 November.
14.
No.
MS D Burgohai doesn't constitute. No, hard miss MSD with D Burgohai doesn't constitute. Mr.
L. Gogoi. L. Gogoi.
L. Gogoi. Learned counsel submits that Mr. T.C. the learned counsel, Mr. T.C. Chutia, learned additional senior government advocate, Mr. T.C. Chutia, who is dealing with this matter, is on next in some other. Okay. Therefore, phrase for adjournment of the matter. Accordingly, let this matter be listed on 14th, 11/26.
Okay.
Okay.
Yes.